going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. Happy Thursday. Happy Thursday. Oh, almost Friday, almost the end of the week. Well, one more day left of court. So, almost the end of the week. Anyways, hope you guys are having a great day. I've got a complete mix of random clips for you guys this evening. I mean, we're jumping everywhere. We're going to start with Judge Washington. I think we end with Judge Boyd, maybe. We're just going everywhere tonight. All right. Yeah, let's go. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
We'll recall the matter of State of Michigan versus Tracy Hoskins, case number 19 FB 1673. First, deputy for the people.
Walter White with Ms. Hoskins.
Thank you. No, Mr. Milton, please, Mr. You need to remute you, sir. All right, go ahead. Mr. White, what would your client like to do?
Your Honor, I've spoken to my client, discussed the recommendation in the report for a brief jail sentence. Her desire is to close this case out. She is currently residing in Greenville, South Carolina, an area I'm a little familiar with since I have a nephew right now in Asheville, North Carolina, just up the road, where they have several feet of water from the hurricane. She would like to get a bus ticket, come up here and do the 5 days and close this case, but I would ask the court to allow her 30 days to report, simply because of the fact that she couldn't get a bus ride up here from where she lives. I'm familiar with the weather conditions down there.
Let me explain something before we go further with this. 5 days is not for a closure. 5 days is for continued probation. That's why it says a review in 30 days. So to continue her probation. If she wants to have her case closed, she can do her time.
All right. Ms. Hoskins.
All right, guys, this is a follow-up to one I did a couple weeks ago, maybe more like a month ago. I don't know. But this defendant used to live in Michigan, was on probation, then she moved to North Carolina. And she was just saying there was no place in North Carolina where she could drug test. So she was missing a bunch of drug tests. And yeah, it was her job to find some place to do her test by the day of this hearing. Now, I think this clip is 2 weeks old by now. Yeah, but it's a little weird because you'll see what happens.
What is your pleasure? What would you like to do, Ms.
This is a 93-day max.
Come again?
This is a 93-day max.
All right. Ms. Hoskins, do you want to come up here and do 93 up to 93 days, or do you want to come up and do 5 days and try to get your probation reinstated and do the other things? What would you like to do, Ms. Hoskins?
I might as well do the 93 days.
All right. Now, how long do you think a month would give you enough time to get a bus that can bring you up here?
Yeah.
All right, Your Honor, I think the circumstances, I think her circumstances are such that probably the only thing she could succeed at from where she is and her income and everything else is jail time. I'd ask the court to consider the length of the jail sentence, and give her whatever your pleasure is, but give her 30 days to report to the county jail.
Ms. McDuffie?
Your Honor, I take, pardon me, the defendants have a right to forego probation and not for jail. So I have no objection to that. I leave it to the court in terms of the appropriate amount of time to provide her for that.
So, your client is denying the opportunity to complete probation.
Your Honor, considering she works at McDonald's and lives in Greenville, South Carolina, I don't think she can complete probation. I think coming up here and doing jail time is probably the only thing she can do. I don't think she can do the other things.
She can't clear up her warrant. She can't take a behavioral program that's online. I don't, and she can't drug test. You tell me they don't have drug testing where she is. I'm not sure. I don't accept that as truth. But if she wants to not do her probation, then we can just give her the jail time.
Ms. Hoskins, do you want to try to complete probation or do you want to do the jail time?
You've been muted, ma'am. I muted you because
I'd rather just do my time.
93 days. 93 days in the Washington County. She actually has 25 days credit. Sentence to begin. On Friday, November 1st. Bench warrant to issue if she doesn't turn herself in, but we'll see how that goes. Probation is revoked. You're all set now.
Thank you, Your Honor. Have a good day.
You too.
All right. Yeah, we don't see that very often. She decided to just do the jail time instead of the probation. Doesn't happen very often. What do you guys think? Think she's going to show up on November 1st? She still has about 2 weeks. Man. Someone who's not afraid to go to jail, I guess. All right. Let's go. Next case.
Jerry Rogers versus Damian McGraw. Mr. Rogers. Yep, got you there. If you could unmute there for me, Mr. Rogers. And then, do I have Damian McGraw?
Yes.
So there, sir. Yep, got you there too. Let's see what we got.
I unmuted.
Okay. Mr. Rogers, it looks like this is your motion to ask me to set aside a dismissal. Plaintiff and defendant. Oh, nobody appeared on September 10th.
There was a mix-up, Your Honor. I was accustomed to getting a letter, telling me what date it was, and I guess it's been a long time since I've had to evict anyone, and evidently they put that in your paperwork they give you back, and it was hard for me to read it. It's carbon copy, and I didn't realize it for that first week. That the process server normally calls and tells me that he's made service, and he never called me either. So it was just a comedy of mistakes.
Sure. Let's see. In fact, I think. Yeah. Oh yeah, there it is. I do have the proof of service in the file as well. Mr. McCraw, anything he's asking
Yes,
him
sir.
beside the dismissal. Are you still at the property?
Yes, sir.
Okay.
I'm in the process of moving out due to the fact that I moved into Mr. Rogers' home, and he told me there was no problem with mold. Now, I know that Michigan basements get wet. So when I noticed that it was mold coming into the basement, I contacted Mr. Rogers, and Mr. Rogers immediately told me to basically just get out his house. So I asked him, I said, well, you're not going to even come over here and look and see what's going on, Mr. Rogers? Mr. Rogers has not showed up to his property since I acknowledged him about the mold problem. Now, when I moved into the property, meeting the neighbors came and immediately told me, like, you're going to have a mold problem in your home. I didn't go off of the neighbor's word of mouth. So once I seen it happening, I mentioned it to him, and the owner of the home just won't do anything about it. But he's steady requesting rent from me.
Okay, so Mr. McGraw.
Not really. I will update what I know for those of you that missed last night or missed Members Monday after this clip. But I don't want to take too long of a pause in the middle of a clip. But I'll throw an update out.
Let's just not get into the whole case right now. Do you want to speak with legal services, or are you just moving? I guess that's maybe we need to start off there.
Yes, I want to speak with legal services because I don't want an eviction on my thing, but I also want to speak with them to see if something is done about this, Your Honor.
Okay. So for both your sakes, rather than extend this thing out, I'll grant the motion to set aside the dismissal. Mr. McCraw, I'm going to let you speak to legal services, and we'll set this. Turn this to October 8th at 9:30.
Yes, sir.
Okay. And Mr. Rogers, we'll set for next week. I'll let him talk to legal services.
That'll be fine. Was that October the 8th, Your Honor?
Yes, October 8th at 9:30.
Sir, I don't know if you want to hear this right now, but I would prefer, I'm not going for a money judgment. I would just like to get him evicted if I could. He swore at me. He's chased me in my car. He's done a lot of bad things, and I would just like for the man to move. I put I had someone bring a humidifier in for him. I've done several things. I had a mold exterminator person come out several times. He said someone would always be there to answer the door. Nobody ever answered the door. He has been totally uncooperative. So I don't think we can work together.
No one has showed up to my house, Your Honor. I have a stay-at-home baby mother.
Sir,
she's never gone. No one. I have cameras at this house. No one have came here.
Okay.
Rogers,
I personally came out with one of my workers several times, and he told me someone would always be there. No one ever.
Your Honor, I would just like to go.
Okay, I'm not going to argue with
legal
him.
service
He's going to interrupt
with him.
Well, it might be, you know what, you guys are kind of almost on the same page as it is. Just hold on, Mr. McCraw. Let me just kind of figure out what, Mr. You just want him to move? Is that what you want?
I just like for him to move, sir.
Okay, so let's just leave that. Mr. McGraw, it sounds like you were in the process of moving. Are you moving anyways?
Yes, I am in the process of moving. I'm trying to find a home. Okay, but this man is he keep threatening me to come and throw me out when I'm telling him, like, hey, you have to give me time to find a home. It's not easy finding a home. And you still want your rent.
Okay.
I lost a lot of stuff in this basement. A lot of my property got destroyed behind this mold in this house.
Okay.
I would like to speak with legal services.
Yeah. Yeah, no, that's fine, Mr. McCall. I just thought maybe I could work it out with both of you. But let's just leave that on for next week, October 8th. Mr. Rogers, would you?
Yeah, not only is that guy smoking, he's had the cigarette in his mouth for a minute and a half, 2 minutes now. Not even taking it out of his mouth, just smoking without using his hands. It's an interesting technique. I don't know if I'm upset or if I'm impressed.
Yeah, and I'll let him speak with legal services.
All right, sir. Whenever I try to talk to this man, he swears at me, he cusses at me, he uses vulgar language, and I can't handle it. I'm an old man. I just can't. If we can't get along, I just would like for him to leave, you know. I've tried my best to satisfy him any way I could, but I've gone a long mile, and I just would like for him to leave.
Your Honor, if I just may, because I am going to probably be assisting Mr. McGraw.
He's on a
Mr.
month.
Rogers,
He's
Mr.
on the
Rogers.
month-to-month rental, sir, Your Honor.
But Mr. Rogers, and that's what I'm here to point out, is that you filed a non-payment of rent case. So the case at hand right now, if you want him to leave, you can serve him a 30-day notice and proceed that way. But you've served him a non-payment of rent case that he is able to raise his defenses of whether the condition of the property is up to the amount of rent that he's supposed to pay. So if you want him to leave and you don't want to worry about the money, then you can serve him the proper notice today for 30 days to vacate. But if you filed a non-payment of rent case, Mr. McGraw, who I'm intending to speak with, has a right to raise his claims about the conditions of the property, and the judge awards whatever amount is owed. Mr. McGraw can pay that and continue his tenancy. If you want to end the tenancy, you can't circumvent the system by filing the short non-payment of rent 7-day notice. You need to file the proper 30 days. So
I gotta mute Mr. McGraw there. Mr. Rogers, he's just trying to tell you what he is likely to be arguing for me as well. So I would keep in mind what he's telling you. If you want to do that,
I
you
have to send out a 30-day notice, Your Honor. I can do that if that's what he's asking me to do, you know, but, you know, the man calls me different, bad names, cusses, swears. It's just,
Yeah.
I can't deal with him.
Yeah, Mr. Rogers, I understand, but particularly where you guys are kind of got this relationship going on right now, we got to either get it taken care of one way or the other. So I guess
I'll send out a 30-day demand if that'll help. And then are you going to have us come back then next week, or do you want us to wait?
I've left it on for next week. Mr. Lowry, does that still make sense for you guys? If I just
yeah, I mean, I think
Mr. McGraw, please don't unmute. Honestly,
my thing is that you know, I'm prepared to advise Mr. McGraw and let the court decide what's owed in rent. If Mr. McGraw pays that, it's only going to just continue his tenancy. If Mr. Rogers wants to leave this dismissed and proceed with actually terminating him the way he's supposed to under the law, then I'll leave that up to Mr. Rogers. But
yeah, Mr. Rogers, I guess you see, Mr. Lowry's trying to give you the practical side of it as well, too. It's up to you. Actually, it might be if Mr. McGraw's going to. That's why I tried to kind of, now I'm getting in the middle of it too. I'm trying to get both of you.
That's why I tried to help for you, Judge.
Yeah.
At least he's hearing it from me and not from the bench. So,
I guess let's just leave it like it is and let Mr. Rogers decide what he's going to do, and I'll leave Mr. McGraw to talk, and we'll figure it out. Okay.
Mr. McGraw, he'll put you back, and we'll talk to my staff, and we'll get you set up, and I'll talk to you. Okay.
Okay. All right, Mr. McGraw, just stay right there. I'm going to set you back. And then Mr. Rogers, on your end, just do whatever you think you want to do, okay?
All right, right. I'll be back next week, and just in case, I'll go ahead and send a 30-day out also, just to cover myself from that end if I need to do that.
Okay. All right. We'll address everything. You got to bear with me. I can't give anybody real legal advice, so since I'm going to end up hearing both sides. So let's do that, okay?
Yep. After this experience, I think I'm about ready to get out of the rental business.
Okay. All right. We'll see you next week.
Thank you.
All right. Bye. And
yeah, that one was quite interesting. The legal aid attorney jumped in and, you know, before even talking to the guy, it just kind of laid down the facts. It was interesting. That was Judge Goggins. Oh yeah, I told you guys I would give you an update on Haley. So for everyone that hasn't been here this week, see, Haley's next case is November 1st. That's her adjourned date where she has to decide if she's going to stay in the apartment or leave. Yeah, so that's up to her. I said, when was the last time I was there? Last Friday. I said last Friday night that I don't think I'm going to go up for that. I believe my time in Haley's case is finished, but I have been collecting money on behalf of Andrea to just do something nice for her, since she's been spending all this time helping out Haley. Where, yeah, we raised all this money for Haley, so I just want to do something nice for Andrea. So on that note, I did get 2 people to send in money last night after the stream ended. Jill and Daniel, thank you so much, both of you. I will add that to the total. I think we're getting up close to $600 now, guys, which is awesome. I need to go back and count it all up, but it's just sitting there right now. So I just got to go check and actually read descriptions on what people are sending money for, because I've already messed that up a couple times. So got to make sure I get that right. And then I have to go back and add in the super chats as well. But anyways, if you guys want to donate to that, that'd be awesome. Also on that note, Gavin is going to be on stream on Saturday night, so we can have a little chat with Gavin on Saturday night. And before you guys say anything, I know I don't usually stream on Saturday nights. That is generally Heather and I's date night. Our anniversary is actually on Sunday, so we are going to do date night on Sunday night instead of Saturday night, so I will be streaming this Saturday with Gavin. All right. I think that covered those bases. All right, let's keep going.
$24,180. Sanjay Pillay and Rupal Parikh versus Kimberly Ann Harwood on behalf of Pillay and Parikh.
Yes, Judge. Griffith Thomas here for claims.
Good morning, Mr. Thomas. And do I have someone here on behalf of Kimberly?
You cut it out now. You cut it out. I wish I was that good, where I could bring up random comments when they weren't even part of a stream. Yeah, that'd be cool. Then I wouldn't have to be here, like you said.
Kimberly Ann Harwood? Ms. Harwood?
I'm here representing myself, and my father, Chris Kunze, is on. I think he's muted. I don't know. Dad, you need to unmute yourself.
Is Mr. Kunze your counsel, or is he just here to help out?
He's just here as my dad.
Oh, okay, that's fine. He doesn't have to be. He can stay muted then. All right. Good morning to you both, Mr. Thomas. Why is this eviction?
Judge Holmes, this is Sanjay Pillay. I'm the owner. And
Yes. Good morning, Mr. Pillay. Mr. Thomas, why is this eviction sought?
Yes, non-payment of rent. I'm sure that defendant will try to bring up some other items. Defendant chose to renew the lease in I believe May, and is going to argue uninhabitability, which
Mr. Thomas, state your case for me. You said non-payment. How much is the monthly rent?
Mr. Play, you probably know that quickly off the top of your head.
I believe it is $24.50.
Do you believe it or do you know it to be? You're the landlord, y'all. Come on.
I will get you the number in a minute, Judge Holmes. Give me just 1 second.
Good job being ready, guys. Excellent job. Neither one could find the number.
So it's $2,450.
$24.50. Is any portion subsidized?
No, Judge.
All right. And what months of back rent have been unpaid?
July, August, and September.
Okay. So it hasn't been paid since July?
The last payment was June.
Okay. And is this property under the Federal CARES Act?
No, Judge.
Okay. What day was the notice to vacate?
That was posted on, sorry, I had it up, but I gotta get back to it. September 3rd.
And how was it delivered?
Via posting and regular mail.
Okay. All right. Good morning, Ms. Harwood.
Good morning.
Mr. Thomas says that on behalf of the landlord, the case they're seeking is about non-payment, so they're not alleging any kind of lease violations. He says that for non-payment, rent was due in the amount of $2,450 each month. Is that correct? Is that the monthly rent, $24.50?
Yes, Your Honor.
Okay. He said that rent wasn't paid for July, August, September, and now October. How about for July, August, and September? Is that correct?
That's correct.
All right. Ms. Harwood, now would be your opportunity to speak. Typically, with that information, the landlord's meeting their burden for a non-payment case, but what information do you want to share? What questions can I answer?
So yes, Your Honor. The residence remains uninhabitable. It on July 5th, the home flooded with sewage and Category 3 water, and we have experts, 360 plumbing, sloop septic. You have a septic system that the lease was signed.
Ms. Harwood, I'm sorry. I hate to interrupt parties when they're giving me their narrative.
That's okay.
You said the home flooded on what day?
July 5th.
But rent was due on the 1st, correct?
Yes, ma'am. Yes,
So
yes, Your
was
Honor.
rent already late when the sewage plumbing happened?
Yes, yes, Your
Why
Honor.
was it? Just focus on that alone then. Why was it not paid on time in July?
That was my oversight. So other than my oversight, Your Honor.
Okay, but I just want to highlight, Ms. Harwood, that the fact that you missed paying the rent on time in July is going to give them the right to be able to evict you today, regardless of what happened after that.
Yes, Your Honor.
Okay, but go ahead and tell me.
Your Honor, I'm already out of the home. We moved out of the home on July 20th because it's uninhabitable.
Ms. Harwood, let me stop you right there. When you say you moved out, did you remove all of your belongings?
We had to move out because the home was contaminated.
Ms. Harwood, yes or no? Did you
No,
remove
not all. No, Your Honor. I apologize.
Are your belongings still in the property?
No.
When did you get all of your stuff and move out?
The movers from the insurance, this was in mid-August, and then I kept the kitchen items because we intended to go back after Mr. Pillay had repaired and the septic system. There's nothing, when we officially moved out, right after the notice to vacate. So.
Okay, so Ms. Harwood, plaintiff gave you a notice to vacate for an eviction and you moved out.
Correct.
Is it your testimony today that you are no longer living in that property, that you and all of your belongings have been removed?
Yes, Your Honor.
When did you give the keys back?
I have not given the keys back yet. Your Honor, so let me, if I can explain, please. On August 8th, Mr. Pillay gave a notice not to renew, which in times past, we've never not renewed, right? The lease requires a 60-day notice, which would be October 8th. And then he sends me an email on August 30th saying, you are correct, you have 60 days. And then they did a notice to vacate. So, and the home, it remains uninhabitable and is contaminated and requires restoration. So I had no intention of moving from this residence. I've been a wonderful tenant. We've had a great relationship that I've sustained, other things health-wise and being contaminated and being exposed to this sewage. So I'm not understanding. And I actually have an email dated August. I have an email from Mr. Pillay saying he wasn't going to charge rent because of the condition of the place. And this is dated August 8th. So there's a lot more here than.
Has that email been sent to the court?
No, Your Honor, but I can forward that to you.
Well, it might be useful. We'll see. Okay, Mr. Thomas, a lot of questions on this one, right? So I get you on July, but if she can't live in the place and she actually moved her stuff out, she just maintained the keys, and if she's got an email in August that says he doesn't want the rent, why should I award September rent?
Judge, I mean, quite frankly, my client's not pursuing rent. He just wants the tenant out since she is not paying rent.
So it's just a possession only request?
Yes, Judge.
All right. Well, with that then, that's pretty much it. All right, Ms. Harwood, the landlord is not seeking any amount of back rent. Instead, they are alleging that the reasons they can't evict you are that you didn't pay rent on time for July, and then they said they included August, September, and October. And while there seems to be some confusion about what happened or what the party's intentions were for August, September, and maybe even now October, the July portion seems not in dispute, right? Rent wasn't paid in July.
Your Honor, if rent was paid, would be paid with the late fee. So I've never had.
Ms. Harwood,
yes,
legally, the landlord can evict you even if you pay the late fee, because once you don't pay it on the 1st, you have breached the lease. The fact that the landlord may allow you to stay and pay a fee does not waive their right to evict you. And I think that may be the best thing I can explain for you, because people confuse that a lot. But if the lease says it's due on the 1st and there's a late fee, it's due on the 1st. The fact that they allowed you to pay it with a late fee is a courtesy that they do not have to legally extend to you. And that's essentially what the landlord is saying, is they're saying, we don't want any more courtesies. We want our property back. And we want it back because you didn't pay it on time, specifically in July. And then he also said for August and September and October as well. For me, the part that's clear cut is that July wasn't paid, and it doesn't look like it was ever paid. Is that correct?
Right. Well, Mr. Pillay on August 8th, which I can certainly forward you to the court because I did file a response, stated in his email that he was not going to charge July rent because of the condition of the place. And the condition of the place remains the same, if not worse. I have video of August 27th.
Ms. Harwood, just show me that email. Mr. Thomas, do you know if your client sent such an email? Because this is a huge thing. If your client retroactively said, I don't want the rent, you can't now come and allege she didn't pay. So do you know if Mr. Pillay, if that letter, if she's going to send me an email that's going to say exactly what she just swore in court it says?
Judge, I can, I'll provide testimony via my client. I do know that my client had attempted multiple times to, what he was trying to do is just, hey, we won't pursue unpaid rent if you vacate.
Is that what it actually says?
Mr. Pillay?
I will have to look through the email trail.
Okay, why don't we take a minute here then? Ms. Harwood?
Yes.
This is an extremely important email for you. You need to send it to the court immediately.
Yes.
Mr. Pillay, Mr. Thomas, if y'all want to use a breakout session on the sidewalk so y'all can confer with each other about this, we'll put it on recall and we'll come back, all right?
Okay.
All right.
Yeah, I had a feeling that did that. I didn't put part 2 in this. Now I need to go back and look for part 2. I forgot that they that happened. All right. I need to go look to see if I have part 2. I'm not gonna have that ready tonight because I'm gonna have to go through and clip it out. But I'm gonna do that for tomorrow. I know I saw the end of it, and I'm not gonna spoil it for you. So I'm gonna look for that and I'm gonna put it tomorrow. Just yeah. Okay. All right. Sorry guys. I thought I had it all together. I did not. Another reason why I'm not AI. Definitely not AI. Real quick, Vic. I'm sorry that I didn't call you out between the first break, but thank you so much for the super chat. I appreciate it, bud. Late fee, my bad. And then I should send it back to you for being late on thanking you. All right. And what else was I gonna say? Oh yeah. No started a channel. I'm sure everyone in chat has been seeing him. He's brought it up a couple times, but he started a channel. He, if you guys don't know, he is obsessed with essentially one court. And a couple weeks ago, they took away the ability to do the live chat. So he started live streaming a court where you can have a chat. So, no, if you want to drop your link, go ahead. I know, Aaron. I know, AA Ron. I done messed up, AA Ron. I done messed up. Yeah, I got you. I have it. I just forgot to put it in this video. Well, hold on. Let me because I wouldn't have put the next case up. All right. Yeah. Sorry, guys. I'll throw up the rest of it tomorrow. All right. There we go. There's no. All right. Next case.
We call the matter of people versus Stephen Forrest Wolf. This is file number 24-6.
This one is just kind of this one's pretty straightforward until the end when the defendant talks. The defendant talks exactly like he looks, and it's hilarious.
Good afternoon, Judge. For the record, Mike Roland.
Larry Brown on behalf of Mr. Wolf.
Thank you. And sir, for the record, are you Stephen Forrest Wolf? Yes.
Yes.
State your address for the record, please, Mr. Wolf.
24.
Is that in Gaylord, sir?
Yes, sir.
423 Maple Street. That's where you'll get all of your mailing in this case. I had a bad address for you, apparently one that was no longer valid. Mr. Wolf, excuse me, I'm Judge Hunter. I'm here to arraign you on an allegation that you failed to appear. The specific allegation is that I required you to appear at a hearing where your attorney and the prosecutor were present and where I was present. But on May 9th, 2024, you were not present. Based upon your failure to appear, I issued the bench warrant in question. Are you aware of the nature of the bench warrant?
I am now, yes. I was incarcerated at the time.
Well, if I would have known that because you provided that information to your attorney or to the court, I may have been able to act upon it. I was not provided that information and neither was your attorney, or he would have been duty bound and would have brought it up to me. So if you fail to appear when you're ordered to appear, the court will issue a bench warrant. If you can demonstrate that you're in jail in a different county, I might use that as a finding of good cause to set aside whatever order I'm going to order today. But for now, what I need to let you know is that if you fail to appear, the court can take action on your bond, which includes a bench warrant. It includes adding conditions of your bond or holding you without bond until this matter is resolved. You understand those potential consequences?
Yes.
I'm going to hear from the attorneys regarding bond, and then I'm going to set this matter for a new hearing for a status conference on your underlying charges. Mr. Rolla, as to bond in between now and a new status conference, what should the court do?
Well, Judge, based upon a number of things, in addition to his failure to appear in this county back when he was supposed to, and again, we had heard, I thought the version was that he was in Bear River, not incarcerated, but be that as it may, he has numerous failures to appear on his record. April 11, 2017, there's a bench warrant out on a motor vehicle theft case out of the 66th District Court in Corona, the $10,000 bond. Bench warrants from 10/24/22 and in a separate case, 11/29/22, both out of the 55th District Court in Mason, cases 20-1474 and 22-1554. As the court's well aware, he has numerous felony priors, which is why he's charged not only in count 1 with possession of methamphetamine as a drug double, and count 2 possession of narcotic cocaine less than 25 grams, also as a drug double and as a habitual fourth. It's a situation where, as I understand it, the court set a bond, or at least our office requested a bond back on 12/12/2023, and I understand Your Honor wasn't the judge at the time. We actually requested $20,000 cash. And again, with the defendant not, whether he was in jail or not, he obviously has not been in jail for over 6 months, and he still failed to contact his attorney or the court. So I think he's still probably in contempt. And I think a significant cash bond is necessary to ensure he's going to be here for his next hearing.
Mr. Brown, on behalf of Mr. Wolf.
Your Honor, it is my excuse me. It is my understanding that Mr. Wolf turned himself in on this warrant. I'm not sure how he found out about the warrant. I would like to clarify a little bit. Mr. Wolf may be able to do this too, but I did have a conversation with him yesterday. When he says incarcerated, I am not sure if that actually means in jail, because he kind of viewed where he was at as being incarcerated, which was in Lansing. I believe he was in a rehab. I believe he also checked himself into a psychological ward at a hospital down in Detroit. How long he spent there, I'm not quite sure, but I don't have enough information if he was unavailable to appear. That's really all I have at the moment. I'm going to need to speak with him further and try to get some of these records to see if there was a true inability to appear.
So, Mr. Wolf, the purpose of bond is generally viewed as twofold in the state of Michigan. Number one, it's to ensure your appearance at future court dates. And number two is to ensure public safety. In this particular matter, as the parties have noted, and as you likely clearly understand, you're charged with felony offense of possession of methamphetamine, both as habitual fourth and with the second or subsequent offense. Those are significant allegations which carry with it potential significant consequences. With those increasing potential consequences comes a bigger risk of non-appearance, because unfortunately sometimes people choose not to appear to face those serious charges. So your appearance and your lack of appearance obviously is not excused by the court at this point. If you provide
Guys, I am sorry. I have no idea what's going on with the audio. It keeps going up and down. No idea what's going on. I'm sorry. I'm gonna guess that's on my end somehow, but I have no idea how it's happening.
Information significant to convince me that all of the gaps of information that your attorney has and all of the gaps of information that I have can be somehow filled in with proper information, then I might reconsider. But at this point, I have no real basis to believe that you're going to appear outside of you telling me, and you haven't specifically said it, but I imagine you would, tell me that you'll appear if I give you the chance. So I'm not convinced that any real amount of bond is going to completely satisfy the court that you'll appear, but it's also not my view that canceling bond altogether is appropriate at this juncture. Your prior bond, the court notes, was $20,000 cash or surety. I think it's appropriate in this case to increase that bond based upon a failure to appear in the last at this point being provided. So the court will set a cash or surety bond in the amount of $30,000. I will require that you post a new bond and then personally appear at any arraignment, any other court date set by the court. You may not use alcohol, marijuana, or illegal controlled substances. And you must immediately update the court in writing of any change of address or telephone number. Do you have any questions regarding those bond conditions or the amount, Mr. Wolf? Hearing no answer to the call of the.
No, I don't give a shit. Don't bother me.
All right.
Mr.
We'll
Roller.
see you at your next court date. I'm going to set the matter for a status conference at my next available date, and you can be heard further at that point. Thank you.
Oh, okay. Yeah.
All right. I honestly kept the only reason I shared this video is because at the very end, what he just said, I still laugh every time I'm seeing it. Do you understand what I'm saying? Yeah, I don't give a shit. Like, all right, guy. Even his defense attorney had to cover his mouth because he started laughing. Yeah. All right. Next clip. Let's move on. I don't give a shit.
Court does call the case. People versus Nani Wesley.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Ms. Wesley. Nani, can you please state your name for the court?
Yes, my name is Nani Wesley.
Your Honor, we're waiving the preliminary examination. I know there's a bond violation hearing that needs to be addressed.
Yes, you need to address that now.
Your Honor, she will be acknowledging and admitting to the bond violation. And hopefully I can say a few words after that.
Go ahead.
Your Honor, I did submit some documents to the court. Hopefully Your Honor has had a chance to review those. She's been treating with the Home of New Vision since about 8.
Yeah, I like him too. He does a good job. And when I first read that, I did not read that as public defender. I read that as a different word that has a P and a D in it that I'll get in trouble for saying on YouTube. Yeah, this is why it's good to actually read. You know, words mean something.
Of this year, and she attends AA meetings pretty regularly. Nevertheless, this is.
When did you send documents?
Yesterday, Your Honor.
Okay, go ahead.
That looks like one of them. She's been treating with Home of New Vision since April. She's going to AA quite a bit. It is a struggle, though, Your Honor, and she admits the struggle. She has gone back to Home of New Vision. She has spoken with them. She's told them about what's going on. They're giving her some things to do to redouble her efforts. I'll just give Your Honor a minute to read if you'd like.
Go ahead.
They've had her go out and get a sponsor. She's been working with a sponsor now. I've attached a letter from her, Your Honor. She's really been pushing Nani to get new strategies in place, new ways of dealing with things, new ways to address her thoughts and behaviors as it relates to drinking. And she appreciates that pushing from the sponsor, Your Honor, and she can tell you that as well.
Go ahead.
She has been putting in some very serious hard work, Your Honor. We're hoping that the court can take that into consideration and please give her a second chance at this, Your Honor. She went to Home of New Vision again this morning, and they hooked her up with a recovery coach. She gave me her card from her, and she says that they've been also giving her new strategies as well in dealing with this. So she does admit the violation, Your Honor. She is a bit ashamed of herself, given that she's trying to put in a serious track record to get to this point. But she's dealing with it as proactively as she possibly can.
Well, then when it was asked about, why didn't she just say what happened?
Freaked out, got nervous. There's no good excuses for it, Your Honor.
Well, but there were numerous times she could have, like a better term, just come clean on it. She didn't do it.
It's hard.
It's not like they just asked her once, and they wanted her to take an ETG, and she sat there and skirted around all of that.
She got scared, Your Honor.
Just let them do anything.
Your Honor, the concern of the people here is that this is a true fourth OWI. Priors in 2005, 2015, and 2018. The alleged BAC at the time of the stop for this case was a .214, and we have a confirmed drinking event while she's on bond. The public safety risk dependent forces is extremely high. People are concerned that if she's not put on a scram, or if there are not other steps taken to make public safe about what might happen. This event, fortunately, it seems like it is being taken seriously. History of the defendant with alcohol cannot be ignored by the people. We are requesting either a remand or a scram tether installation before she leaves this immediate vicinity.
How come she didn't take the ETG?
Right then and there, Your Honor.
Hmm?
Right then and there, Your Honor. She did take the ETG. It came back to on-site.
At what point?
I don't know that, Your Honor. Yeah, you of course can talk when the court's ready for you. Yeah. Are you asking Ms. Wesley?
I'll hear from her.
Okay.
Your Honor, I did take it the same day that I was asked to take it. I wasn't in town. I told her I wasn't in town, and she said that I needed to take it, which I did do. I came back to Ypsilanti to take it. I was not in the area.
It is not a Mr. Allen emote. It's a buff lift emote. See? That's how it comes up on my side. I smell a buff lift coming. When I bring up the comments of the emotes, it actually says the title of the emote. I think it's hilarious.
I guess my question, you took it on what day?
The same day that she requested the 3rd.
Why didn't you tell her you did?
I did tell her, Your Honor.
When?
I told her.
What? Okay, let me ask this. Why was your story changing?
I was nervous when she called me, and I told her that I wasn't in the area right away. And she said, well, where are you? And I said, I'm out of the area. I'm up north. And she said, well, your device isn't up north. It's in Detroit. And I told her that I would come back if she needed me to. And she said, well, I can give you some places where you were at to test. And I said, I will try to make it back so I can do so. And I did do that. I did it the same day she asked me to.
Your Honor, if I may, the report that I received does indicate the testing was done on-site, not community corrections. And I also have that same information, I think the court has as well, where the initial information that's provided by the defendant to community corrections is that she was up north and unable to do that. But that 20 minutes before this contact, GPS and SoberLink said she was in Detroit. And then the defendant said she didn't have it with her, SoberLink.
I didn't physically have it with me, Your Honor. I wasn't with the SoberLink. That's what she was asking me, the corrections officer. And I told her.
Where up north were you?
In Dryden, Michigan.
In where?
Dryden.
So, Your Honor, I mean, bottom line, she did.
Yeah, her story doesn't make sense, and not a good idea to lie to Judge Simpson. I don't remember if Judge Simpson calls her out online, but when you're on the SoberLink, you know you need to carry that thing with you at all times. It's a part of the discussion when you get it. And, you know, you're going out of town. Yeah, doesn't make any sense. doesn't make sense for a lot of reasons.
They come back to do the ETG knowing that it would be positive and knowing that this court would take that into account. She has been scrambling this past week to try to get things into place. I think with everything she's been doing since April, with what she's doing now in combination with the scram tether would keep her on track, Your Honor.
No, the SoberLink is like a handheld breathalyzer that you have to carry around with you. But it's not attached to you. The scram tether is attached to your ankle. I honestly don't know why there's two. I don't get it. I don't get why there's two different kinds of alcohol testing, for monitoring. They should just stick to one, right? I mean, if they're going to do the breathalyzer, the handheld, do the handheld. If they're going to do the anklet, do the anklet. I don't know why there's two. That doesn't make sense to me, at least.
How is that going to keep her on track?
It'll make sure that she can't drink.
No, she can still drink.
Well, tell her she does.
I promise you.
Much like this did. And then when they call her on it, she starts all kinds of excuses, Mr. Allen.
I'm begging you, Your Honor, I will not. I have, at the time, did not have a sponsor in place. I have a sponsor now. I'm working with Home of New Vision on a weekly basis. I see the treatment coordinator. She did submit a letter to say that. I told her right away.
Ma'am, this is the fourth time. Then you get caught the fourth time. You're almost 3 times the legal limit. You get a bond. You're out. We put you on a SoberLink.
Yeah, that's what it is. The SoberLink will tell you. Like it'll start beeping and you have to blow into it. It's kind of like one of those interlocks you put on your car. It'll just randomly start beeping and you have to blow into it. So yeah, I just don't get it. I know that there's pros and cons of both of them, but I don't know if I was ever in a position where I needed this little handheld breathalyzer thing, I would ask for the anklet just so I didn't have to worry about it. But the anklet's probably sucks more. But anyways, I just said sucks. Okay, let's keep going. Let's stop rambling.
You drink. Then when you're called on it, you begin this whole thing of going around it and everything. And that's what gets you into treatment.
Well,
So what you want me to do is you want me to take the chance of putting you on a scram tether, allowing you to get behind the wheel of a car, maybe having drank,
Your Honor.
and hurt or kill somebody. Not going to happen.
Your Honor, I won't do that.
Bond revoked. Defendants remanded. I'll adjourn this out 1 week.
We are waiving the preliminary examination.
I'll adjourn it out 1 week. She can do the waiver then, but she's going to do this now. October 24th, 2024, 9 a.m.
You know what? That does make sense. I think you're right on that. I think it does. I think you're right. Yeah, I'm never going to be in a position where I need either one of them. So yeah, but just something that confuses me why there's two different systems. Anyways, let's move on. She got revoked. I know that one's kind of been floating around. A lot of people have seen it already, but it's Judge Simpson and it was good, so I kept it in. All right, I think we might be moving on to the last one. I think this is Judge Boyd.
Tony Morado. Who's here for Tony Morado? And does she have a warrant or no?
Last one, unless you guys talk me into doing a bonus clip. We'll see. I know I've got a couple ready to go. We'll see what I have.
Oh man.
Okay.
I'll wait till.
Is this still going to be a contested?
Well, Judge, I really honestly don't know. I have a request for the
court. I'm not prepared to have a contested hearing today.
All right.
My request is a reset.
All right, it's going to be a short recess. And let me tell you all why. This case was brought to the court on May 22nd, 2023, and it was reset for June 1st for a contested hearing. On June 1st, she did not show at 10:10 a.m. So then a warrant was issued for arrest. She was remanded without bond. I guess somebody unremanded her. And so today we're set for a hearing.
There seems to be a little discrepancy. I don't know if the court has it on the court file. I conferred with Deshaun. It says bond forfeiture?
Mm-hmm.
Because when we checked the clerk's record, it didn't indicate that. It indicated a warrant had been issued on that date because of a drug court evaluation that went south. Not of a, she doesn't recall missing a court date. And I'm not arguing with the court. She may have. I was not here at that time.
I understand. No, I will tell you, somebody else gave her bond back. It wasn't the court because she didn't show on that date. So that's neither here nor there. She doesn't have a warrant for arrest, which is what everybody is telling us. So my main thing where we are is this motion to revoke was set on May 22nd. Then it's reset for June 1st for a contested hearing. And June 1st, a contested hearing didn't happen because she didn't show.
Right.
So now we're back on October that we've been trying to have a hearing since May. So what I'm saying is, I understand you say you're not ready for a contested hearing. It's going to be a short reset. So my reason for saying that is because it's a short reset.
I understand that. And I know you want to move this case, and I understand that as well. I don't plan on contesting the motion.
Okay.
I'm trying to get Tony plugged back in to start doing what she needs to do. And that requires a little bit more time than the court might want to give in a situation like this. But that is my ask of the court. I need her to get plugged in and start doing some things. I don't think that's a bad thing. And that's what she wants and I want. So to that end, if the court could give us 30 days, I'll defer to the court on the time, but that's my request, Judge.
All right, let me ask this, and we're not on the record. If she's drug tested today, what are the results going to be?
Should be clear.
All right, so let's do a drug test today. Do you need any water? All right, so Miss Abrams, is there a place she can go to do a drug test? I can see if they'll have it if they'll allow her to do a drug test at felony drug court. All right, just have a seat.
Thank you, Judge.
Welcome.
I forgot to do the fade in, fade out. I'm failing all sorts of different ways tonight. All right. What do you guys think happened? She had to do a drug test. This ends a little different than you would think. Oh, also, I'll do one bonus clip. I'll do one. Mimi, yeah, it's true. That is true. She got in trouble with a couple attorneys because of her YouTube channel, which may be why we haven't seen her this week. I don't know. I don't think I've seen her since Monday or maybe Tuesday. I know it's been at least 2 days since I've seen her. Same with Judge Stevens. Neither one of them have been on, and they usually go every single day. All right, bonus clip. I'll play one bonus clip. It's up to you guys, though. Do you want Judge Shackelford? Do you want another Judge Boyd? Or do you want Judge Webster? Those are the three. You can pick. I'm not going to tell you what the case is about. You just have to pick by judge.
So I'm being told that they're here in the building, but she's very terrified about coming up here. I've implored her to get up here.
How long she needs to come in?
Judge, I have for the last half hour. So this is, if you will allow me, I have a client at my office right now that I need to talk to. Can I be excused?
Well, do me a favor. If you will let her know that if she's not in here in 5 minutes, that a warrant is going to be issued.
I've already told her that.
Okay.
I literally texted her that,
Okay.
that you're wanting to know where she's at. She's late and the warrant's about to go out.
Okay.
Verbatim.
All right.
So
Well, you can,
I will be close by, and I do have my phone, and I know the court, Norma knows how to get in touch with me. I'm not gonna play this game with her, not with the court.
Yeah, no, well, I'm gonna issue a judge's warrant
Okay.
and I will remand her with the stop on. So I'm seeking to file on, I'm sorry.
Tony Morado.
Morado.
According to the attorney, she's still in the building. She's just not coming forward. Oh, there's ways they can make her come forward. But yeah, I believe she might be telling the attorney she's still there. Like she might be in the bathroom or something. No, she dipped. She tested positive and she ran.
All right, let's just put this on the record briefly.
Sure.
All right. Court is calling 2022 CR 8639, State of Texas versus Tony Morado. Can I have parties announced for the record for the state? Defense.
James Tochi for Miss Morado, James.
All right, this was set this morning. Miss Morado was going to do a UA. The court is in receipt of those results as well as defense in the state and probation. She was supposed to be back here at 1:30. I think both parties have received information that she has left where she did the UA on Kamal Street. Is that correct?
Yes, Judge. In fact, I'm in phone contact with her, and my understanding is she's actually in the building, according to her, and is very scared to come up here. And I've explained to her that she's likely to be taken into custody. I've also explained to her that we're talking about some options potentially. It could be good for her. I have implored her to come up here several times via text message. I've gotten no response other than we're here in the building. I'm trying to get her up there. He's her boyfriend too. And so far, I have not yet seen her. I've not gone down there, but I plan to in the next couple of minutes.
All right, state.
State's requested a judge's warrant.
All right, the court will issue a judge's warrant and remand your client without bond. If your client shows, we'll get in contact with you, counsel.
Thank you, Judge.
All right, you're welcome. Thank you.
All right. Bonus clip time. Who said that? Isn't that special? You know what? I don't know. I don't know what happened to him. Just a lot of courts they just decide to stop streaming. You know, and it just happens overnight. It's not like we know what's coming. Just one day they just stop going live. And I actually haven't even thought about Judge Dad for a while now. So that tells me that it's been probably a few months since the last time we've seen him. But yeah, no idea. Okay, bonus clip. I saw more Shackelford than anything else, so we'll do Judge Shackelford. And I actually should have played this with the guy last night because this guy's creepy, just like the creep from last night. But Judge Shackelford, let's go. Well, we don't need to see my intro. All right, now let's go.
Okay, this is 241114 SM, the people versus Austin Floyd.
Good morning, Your Honor. Jeffrey Fansel on behalf of Mr. Floyd. We've had today's time date set for sentencing. We've had an opportunity to review the pre-sentence report. Same appears to be factually accurate. No corrections, additions, or deletions need to be made. I would like to, I put little boxes there, a couple of things that I'd like to address.
Speaking of Shemke, one of the times I was in Judge Simpson's courtroom for the Haley case, he was there. So I got to see him in person. He's tall. He's a little bit taller than I would have thought, but he's about my height. So Shemke's a tall dude. No-No's yelling at me. Stop yelling at me, No-No. Oh, okay. All right, I'll check it out after this. Thank you. Thank you, No-No.
In terms of the recommendation.
Okay.
Judge, there is nothing in this report or anything that has anything to do with alcohol. They did an evaluation. It's low risk, low needs. And so I don't see any reason why alcohol restrictions would be, he knows he can't do illegal drugs and he has to use alcohol appropriately, but there's no reason why he should be restricted from doing so.
Hello?
Sir, if you can just hold a moment, you're in a courtroom. Way to take responsibility for your actions, sir. So he claims he did nothing wrong when he sent nude photos of his former spouse to her entire family, and it was just all an accident. Okay. Sir, I hope you learned something over the course of probation. Like, I don't know, how to act like an adult and how to take responsibility for your actions. What you did was repugnant and retaliatory. And I understand you might have been in circumstances where you were ruled by emotion, but now we're months past the incident and you literally take no responsibility for what you've done. And in some states, this is a felony. It's revenge porn. It's a felony in a lot of states. $50 fine, court costs of $50, state costs of $50, and a victim's rights fee of $75, probation oversight fee of $450, and community service fee of $10 per day, for a total of $50. You're to do 12 months probation. You'll complete 5 days or 40 hours of community service as directed by probation and provide proof. He wasn't on drugs or alcohol at the time the incident occurred.
No, this is not related to that Judge, at all. And the report, he seems to have been honest with with Ms. Grasso, and she did evaluation of low risk, low needs. There's no indication that that's an issue.
Okay,
I was actually at a doctor's office.
that's classy. All right, you are to abstain from the use of controlled substances unless they're prescribed by a physician for the term of your probation. You will be subject to testing at your expense at probation officer's discretion if they believe there's an issue. You're to submit to a mental health evaluation as directed by probation, follow all therapist recommendations, and provide proof. You will complete an anger management class as directed by probation through ETRS and provide proof and follow all therapeutic recommendations. You'll attend and complete any other ancillary services deemed warranted. You'll stay out of establishments at times. You're to have no contact with Nicole Floyd. You understand me?
Your Honor, she was originally in the waiting rooms, but unless she came back, apparently she left.
I didn't see her.
The parties have 3 children, and quite frankly, she initiates a lot between the parties, and I've explained to him no contact, but I would ask the court consider just relative to kids.
How do they do parenting time transfers now?
Is it, does she have physical?
She will drop them off at my house.
Okay.
So she drops them off and picks them up?
I will sometimes drop them off at her house. Before, we were doing it at a police station.
And then he coaches kids teams and she attends the games and stuff. So I would ask the court, limit it to the children.
Okay. So it's contact only for the purpose of parenting exchanges or other activities involving the children. She's not here for me to get any input from her, but it sounds like they're doing that anyway. You're to maintain employment and provide proof and obtain an order for fingerprints. It looks like you've already done that. Okay. All right. Hopefully you learned something.
Thank you, Your Honor.
You're all set.
All right. That was it. Yeah. this guy. I've got a lot to say about this guy. I'm not going to. Yeah, I think we're all on the same page with him. You should, like I said, I should have paired him up and put this video with the guy from last night. Then we would have just had a "Why do guys suck?" video compilation. Anyways, let's see who can we raid. Who can we raid? All right. I always forget I have to refresh. Let's see. Yeah. Got nobody. Is there really nobody on? All right, I guess we're not raiding anyone. So I guess we're just having a good night. Thank you guys so much for hanging out with me tonight. Thank you for the super chat, Vic. I appreciate it. And I will see you guys tomorrow. Let's see. I don't really have anything on the go tomorrow. This week was a pretty slow week when it came to court. I've got a calendar that I put all the follow-ups in, so I know what courts to be looking for on what day. And I don't think I had one scheduled for this week. Not one day in this week had any follow-ups. But we do get an Eric Martin next week, so that's good. Eric Martin will be back in front of Judge Slavin next week. Excited about that one. Got actually a few soft sits scheduled for next week. Got the Army guy in front of Judge Webster is due back next week. That he actually might be 2 weeks from now. I think Judge Perkins has a soft sit next week. You know what? Instead of just guessing, I'll just keep you updated as it comes along. All right, you guys have a great night. Thank you so much, and I will catch you all next time. Until next time, bye.